Good afternoon, everybody. So far, we have completed discussions up to Article 81. To recapitulate, Article 80 related to composition of the Council of States, while Article 81 is related to composition of the House of the People. In this video, we shall discuss Article 82, which is related to delimitation or readjustment of seats in the Lok Sabha and state legislatures. Article 82 states that upon the completion of each census, we know census should be taken every 10 years. The first census were completed in 1951. Thereafter, every 10 years census have to be taken up. After completion of the census, we know after completion of 1951 census, first general elections were conducted in 1952. The same way, after completion of 2 terms of the parliament, rather after every 2 general elections, new census will be taken up and the states will have to be reorganized based on the new census. The allocation of seats in the House of the People to each state and division of each state into territorial constituencies has to be done after concluding the census after every 2 general elections. However, it is provided that such census or such readjustment shall not affect the ongoing House of the People, that is, the House of the People existing as on that date. So, it is reasonable and logical that each state shall have equal representation in the election of the President of India. This was what also provided in Article 55. In tune with Article 55, Article 81 and 170 relating to the assemblies are also provided the same way, that each state shall have equal number of population, equal number of MLAs and equal number of parliament members, and the population represented by each MLA and each parliament member shall be as far as possible, as far as practicable, shall be equal. However, through the 42nd Amendment of 1976, it was provided that such readjustment shall take effect from the date to be determined by the President of India. We know the entire Constitution speaks about powers, duties, functions and responsibilities and discretion of the President of India, but unfortunately wherever as the President may decide, we should understand that whatever the Prime Minister decides. This is most unfortunate thing that has happened in India after independence. Provided also that the relevant figures for the first census taken after 2026 have been published, it shall not be necessary to readjust. Is there any meaning in this amendment? This amendment of 2001, amendment number 84 of 2001 states that the readjustment shall not be necessary until the census have been conducted after 2026. We know starting from 1951, census have to be conducted every 10 years. So naturally, in 2021, there should have been census. But unfortunately, it is not happening since 2001. So when the next census come after 2026, they come in 2031. So this readjustment should take place only for the general elections to take place after 2031. Maybe since this time general elections took place in 2024, next general elections would take place in 2029 and then 2034. Maybe for the general elections of 2034, this delimitation should take effect as per this 84th Constitutional Amendment of 2001. Till then, the allocation of seats in the House of the People to the states as readjusted on the basis of 1971 census and the division of each state into territorial consciences as may be readjusted on the basis of 2001 census under this article. So this amendment states that it shall not be necessary to readjust the allocation of seats in the House of the People to the states and the division of each state into territorial parliament constituencies on the basis of 2001 census. This is as good as making an amendment. The constitution shall not be in force for a decade. When the constitution so clearly provided that the census shall be taken every 10 years and that allocation of seats in the House of the People shall be adjusted every 10 years and the seats in each state also shall be readjusted after every 10 years. If you make an amendment to the effect that census may not be taken or the readjustment need not be done, it is a very bad idea. Actually, these are the things that the Honorable Court should note as basic structures of the Constitution. As a result of this amendment, there have been constituencies, some parliament constituencies which have 30 lakh voters, and there are some parliamentary constituencies which have 5 lakh voters, and there are MLA constituencies which have 5 lakh votes and which have 50,000 votes, and there are states which have 400 assembly seats and 80 parliament seats like the UP, and there are states like Sikkim which have 32 assembly seats and maybe, I don't know, 4 or 5 parliament seats. Likewise, there are several states like Himachal Pradesh, etc., Uttaranchal, Uttarakhand, etc., which have assembly seats less than 60. True, Article 170 stated that each state shall have assembly constituencies ranging from 60 to 500. It does not mean that some states can have 60 seats and some other states can have 500 seats. If Article 170 is interpreted that way, Article 55, Article 81 and Article 170 totally become useless. The purport of Article 55 is that each state shall have equal scale of representation in the election of the President of India, which means that there shall be equal number of population, equal number of MLA seats, equal number of parliament seats, and the population represented by each legislator and parliamentarian should also be equal as far as practicable. I have heard recently there was some movement, agitation in Tamil Nadu on the grounds that this delimitation will benefit North India. They will have more seats and this will work against the South India. This is a very dangerous and unnecessary argument. This argument is capable of dividing the country into two, South and the North. And moreover, this is wrangling over an ash shadow, because this delimitation applies only to the elections conducted after 2031, maybe 2033 or 34. As such, there is no need to make an agitation now. However, I submitted you in the very beginning that taking not census every 10 years and not readjusting, not reorganizing the states every 10 years and readjusting the seats within the states every 10 years is an unconstitutional thing. Thank you. Thank you for watching my video. I request you to please subscribe, share and comment on my videos. I will be glad to reply to you. Naturally, there would be so many doubts because what I am speaking is against the established practice for the last 75 years. I am speaking with conviction. How many long years there has been a practice? That is not the yardstick to judge whether it is legal or not, constitutional or not. Thank you. Thank you for watching.